Welcome to today's webinar, 2020, the Year in Review, Employment Litigation. This is the third webinar in our four-part series, 2020, the Year in Review. My name is Karen Sargeant, and I'm a partner in the Toronto office. I am also a co-leader of Fasken's Labour, Employment and Human Rights Practice Group. I am joined today by my fellow partners, Bonny, a partner from Toronto, Matthew Larsen, a partner from Vancouver, and Magali Cournoyer-Proulx, a partner from our Montreal office. Before we begin, I have a few housekeeping notes. There will be an online survey at the end of the webinar. Please click the survey link underneath the video to fill in our survey. These surveys help us to determine future topics, and your input is greatly appreciated. For questions, if you have a question during the webinar, please type your question into the chat box beside the video. We will do our best to answer all of the questions we can at the end of the presentation. For technical support, if you require some, you can click on the Tech FAQs or the Tech Support Chat buttons, which are located under the question chat box. If you are looking for COVID-19 specific information, we have a wealth of information in our COVID-19 Knowledge Center, which can be found at fasken.com. And last but not least, our last webinar in our Year in Review series, 2020, the Year in Review Labor Relations, is being held next Monday, November 30th. Please visit Fasken Institute or fasken.com for more information and to register. Now on to our presentation. 2020 has been an eventful year for sure. We have all been dealing with COVID-19. But while that has been happening, the courts have been issuing many employment decisions that affect our lives beyond COVID-19. As the title of our presentation suggests, some of those, but not many, are good, some are bad, and some are simply ugly for employers. So in this presentation, we will summarize these most important cases for you. Just before I hand things over to my partner, Bonny, to get started, I just wanted to let you know that the citations to the cases are at the back of the presentation. So if any of these cases interest you and you want to look it up online, you can do so through the link at the end of the presentation. And now over to Bonny to start us off with the good.
Good afternoon, everyone, and good morning to those of you on the West Coast. It is not often that as an employment lawyer, I get to deliver good news to my employer clients. So I am very happy to have the opportunity to do this presentation today and to share with you today. The first thing is being a good case for employers. So this case is George and Laurentian Bank Securities, Inc. So quite often I would advise my employer clients that if you have an employee who makes over $100,000 per year, who is 55 years of age or older, but short service, then the range of common law reasonable notice tends to be quite large. There tends to be quite a large range in which the court would award reasonable notice. And this is an example of a case where short service actually equals a short notice period. So what are the basic facts of this case? So it's a without cause termination of this employee whose job title was Vice President of Equity Trading. He was employed only for 5 months, not 5 years, and his annual salary is approximately $100,000. Now, this employee is represented by capable employee side counsel with whom our group is very familiar, and he asserts at trial that there is a minimum floor for executive employees of 12 months notice, regardless of length of service. So even though this employee was employed for only 5 months, he was asserting an entitlement to common law notice of 12 months. Now, as you can see at the bottom of the slide, at the end of the day, 2 months notice was awarded. And just when you think, okay, we dodged one, and it means that the court didn't buy into that minimum floor for executive common law notice, it is important to know that in this case, the court actually found that this employee was not an executive based on the actual facts on the ground. Despite having a title of VP, the court found that he actually did not have any direct reports, and he was about 3 levels removed from the senior executive ranks. So the court held that this person was actually not an executive. And on the basis of his length of service, his very short service, his position, and his age, he was 58 years old at the time of the termination, the court awarded 2 months notice. So next, we're going to have Matt Larsen, who's going to talk about a case about improper investigation.
Great. Thank you very much, Bonnie. And if Bonnie has the opportunity to discuss one good case, I'm very pleased to have the opportunity to discuss 3. So lots of good news for employers, but as you'll see shortly, I think, as I kind of walk through these, some of them do have a bit of a cautionary tale as well. So the first decision I'm going to discuss with you today is a case called Luan versus ADP Canada, and it's a decision of the Alberta Queen's Bench and was released in June. And this is quite an interesting case in that an employee tried to claim a new tort, which was the tort of negligent investigation. And I'll briefly explain some of the facts for you or set those out, and then kind of explain why this is good news for employers, but also a cautionary tale. So in this matter, there was an employee who was employed by ADP Canada for about 9 years, from 2006 to 2015. And in 2015, this employee was promoted to a position with ADP Canada's parent company in the US. Shortly after her promotion, ADP Canada received a complaint from an employee at ADP Canada who claimed that Ms. Luan's practices around commission calculations violated some of the company's policies and were unethical. As a result of that complaint, ADP Canada carried out an investigation, and someone from ADP's US parent company was involved in that as well. There were 2 employees who carried out the investigation. The investigation concluded that Ms. Luan acted inappropriately and did breach policies. And as a result of that investigation, ADP's parent company terminated Ms. Luan's employment. As a result of that, Ms. Luan filed a claim against ADP Canada. And it's interesting that this claim wasn't for wrongful dismissal, because at the time that the claim was filed, Ms. Luan wasn't employed by ADP Canada, but instead by their US company, or US parent company. The claim claimed a couple of grounds of damages, one being that of negligent investigation, which I'll get to in a moment, but also that ADP Canada induced breach of contract by inducing ADP's US parent to terminate the employment contract, and also claimed defamation as a result of some of the allegations made in the investigation report. Now, kind of turning our minds to this claim for negligent investigation, the court did conclude that ADP failed to conduct a thorough investigation and that they made unsubstantiated conclusions regarding Ms. Luan, including unethical behavior. However, when the court turned their minds to this claim for negligent investigation, what they found was that there were policy reasons for not finding that there is a tort of negligent investigation for employers. And the reason for this is that they found that this would fundamentally change the employment relationship by creating kind of this duty of good faith. This is something that's been considered by the courts before, who found that there shouldn't be a negligent tort in the employment relationship. Now, this is very good news for employers, as this would have fundamentally changed the employment relationship and arguably eliminated the right to terminate employees at any time without cause upon providing notice. So this is a good decision for employers. It would have created some very kind of unknown implications. However, I mentioned this is also a cautionary tale. And the reason I mention that is that Ms. Luan was successful on her claim for inducing breach of contract and also for defamation. And really, those claims really flowed out of this negligent investigation because that's the basis upon which the company made these decisions. So this is a cautionary tale to carry out thorough investigations and to ensure that any findings are supported by facts. Otherwise, it can give rise to successful claims by employees. So now I'll next turn to the next case here, which is Nagy versus William Rutherford Limited. And this was a decision of the BC Supreme Court, which was released June the 6th. And this case is very positive for employers as it found disrespectful conduct can give rise to just cause. Here, there was the plaintiff was a manager. He was the head office customs and import manager, and had been employed for about 4 years at the time he was terminated. And what's significant here is that his employment agreement included a term that he was required to maintain general harmonious relations with all departments, staff, and clients. And the facts kind of giving rise to the claim here are a little bit interesting. So in November 2018, and a little bit fun, so I'll briefly walk through them. The plaintiff sent what he thought was a funny email to some of his coworkers, in which he capitalized the first 3 letters of the word assuming. So it said capital A, capital S, assuming, which he thought was quite funny. Management didn't think that was quite as funny, so they went to go speak with him about this. And when they did so, Mr. Nagy was quite offended and said, "I quit." He got quite upset. So the next day he showed up at work and tried to kind of rescind this resignation. Management didn't agree and took the position he had resigned. So he left the workplace. Now, following that resignation, the employer came upon another email he had sent about a year prior. And this other email was very critical of a coworker. The other relevant fact here is that he'd sent it to his ex-girlfriend, who was a subordinate within his department. Now that email referred to the local human resources manager as twice as stupid. And as I mentioned, was sent to a subordinate. So the employer took the position this was after acquired cause and gave them cause to terminate the employment relationship. Now this all proceeded to court and a decision by the BC Supreme Court. And what they found is notable for a couple reasons. First, they found that the "I quit" was not a resignation. They found that that was an emotional outburst and did not demonstrate a true intention to quit. Now that's consistent with other case law, so nothing really new there, although it is notable. And then they did find that this email sent to the subordinate criticizing another employee was just cause for termination. And that is notable because it was just one email. And the reason they found that is that Mr. Nagy had been previously warned about disrespectful conduct. Also that clear language in the employment contract where he was to maintain harmonious relations. And finally, and this is maybe the most notable and widely applicable, is that they found there was a really high behavioral standard for managerial employees, and particularly in communications with subordinates. They found that allowing this kind of language and behavior would have a very damaging effect on the workplace and on subordinates. And they specifically commented it would make it hard to hire employees into the workplace. So that's a really good decision, a solid one and one to keep in our pockets. So moving on to the next case here, the third in kind of these positive decisions. And this is a case of Mova Sahai versus Harborfront Wealth Management. I won't go into this one in a lot of detail. There's nothing new here, but it is a positive decision, certainly. So the plaintiff in this case was a certified investment advisor who switched firms. And he had one client who was a resident in one of his buildings, was a tenant, and who happened to be on vacation around the time that he switched firms. So rather than getting that client to sign off on transferring their funds, Mr. Mova Sahai decided he would take matters into his own hands and forge the client's signature to transfer over the client's funds. He said that this was in the client's best interest because some of their mutual funds were about to take a fall and weren't performing that well, and that the client wanted to transfer their funds anyway. He also failed to disclose that this client was a tenant in one of his apartments. When the client found out about this, she contacted IROC, the regulator, and also the new employer and let them know she was not pleased with the forging of her signature. And the employer terminated Mr. Movasahai's employment. The court upheld that, and in doing so, they noted that there's a particularly high standard for honesty in the financial services industry. And this follows a long line of cases which stand for that principle. So a positive decision, nothing new there, but yeah, a good one for employers. So I'll now turn things over to Magali, who's going to discuss garden leave.
So I'll speak briefly about this concept. And the only case rendered in Quebec, which has dealt with a garden leave provision, it's a concept that is very uncommon, not only in Quebec, but also in Canada, but it is much more customary in countries like England, the UK, and Australia. So what is a garden leave? Well, it describes a practice under which an employee who's leaving a job, either because the employee has resigned or had their employment terminated, is instructed to stay away from work during the notice period while remaining on the payroll. So in short, it means that the employee is still employed, but does not have to attend work. So it is most common in Canada to bring an employee's employment to a swift end, and typically an employer will give a payment in lieu of notice. So question that is probably asked is, why would an employer want to put an outgoing employee on a garden leave? Well, employers most often use garden leave during an employee's notice period to prevent that employee from having further access to customers, clients, staff, and basically to prevent the employee from either working for a competitor or helping out a competitor during the notice period. It's sometimes also used if the person, while on a working notice, may be seen as disruptive or likely to have some other type of negative impact on the fellow employees. So the advantage is that while on garden leave, an employee must still observe its normal duty of loyalty provided under the Civil Code or the fiduciary duty of loyalty under common law principles that is associated to any employment agreement. And as well, the employee will have to observe any express restrictions, such as a non-compete or a non-solicit, while still an employee. So in this case that I'm talking about, it's a Court of Appeal decision rendered in 2020, which maintained the first decision of the Superior Court rendered in 2018. And that had discussed whether this type of provision was permitted under our Civil Code of Quebec. And in order to do that, the judge referred to our Articles 2085 and 2087 of the Civil Code of Quebec. And what's very particular, if you look at 2087 in particular, it provides for the obligation of an employer to provide work to an employee. So it states that the employer is bound not only to allow the performance of the work agreed upon, but also pay the remuneration fixed. So obviously, through a garden leave, the question that is asked is whether this is permitted under this section 2087, because the employer under a garden leave provision would no longer allow the performance of the work. So at first glance, it could be challenged under that provision. And what the first judge in the Superior Court decision in the Sennheiser case decided, it said that a garden leave provision is valid in Quebec and cannot be seen as constituting constructive dismissal, because the possibility of changing the terms of the employment and basically removing the employee from his duties is included in the employment agreement. So basing its decision on the famous and old now decision of the Supreme Court of Canada and Farber versus Trust Royal, the Supreme Court had recognized that an employer can make any changes to an employee's duties if these changes are allowed by the contract. And so based on this reasoning, the Superior Court judge stated that an employer had the right, if there was already a provision in the agreement, if there was already a well-drafted garden leave provision, the employer could basically set aside the obligation of 2087 because it was permitted under the contract. So the good news is that the Court of Appeal maintained that decision. It did not discuss specifically the garden leave aspect, unfortunately. It would have been interesting to see whether they had dealt with the possibility of considering that this is a disguised way of applying Section 2095 of the Civil Code. Just to briefly explain that our Section 2095 of the Civil Code states that when an employer dismisses an employee without cause, then a non-compete is not enforceable. So basically a non-compete provision would only be enforceable if the employee resigns or is terminated for cause. So a garden leave provision is a good way to go around that article because during the notice period given by the employer, an employee could be forced not to compete against the company. So I think it's something that is certainly not used enough when drafting our contracts of employment, but that should be taken into consideration. So I'll now, unfortunately, we'll now pass to the bad.
Thank you very much, Magali. And I'm now going to, unfortunately, I talked about some of the good parts here, some of the good decisions. So now I'm going to have to kind of speak about some of the less favorable decisions for employers. And the first one here is Acumen Law Corporation versus Ogenin. And this is a decision which received quite a bit of publicity in British Columbia. And the reason for that is that this was a case which involved an articling student and her principal and principal's law firm. And what happened here is the principal's law firm was a firm specializing in roadside law. And there had been a couple little disagreements between the firm and this articling student, but nothing major. And then the law firm discovered that this articling student had set up a blog with her husband, along with her husband, which was called roadsideprohibitions.com. And her articling principal responded very negatively to this and without doing an investigation, terminated her for cause and also filed a claim against her, citing a number of things, including breach of contract, trespass, theft, and the wrongful use of marketing materials. And the employee in turn filed a wrongful dismissal claim against the law firm, claiming damages for wrongful dismissal, as well as mental distress, bad faith conduct, and aggravated damages. Now, the judge who heard this matter dismissed the law firm's claims against the employee, but upheld the wrongful dismissal claim. I won't go through all the facts, but essentially, it kind of it's an interesting read if you have some time and feel like giving this a read. But the court found that there was no theft, no trespass, and the facts here, those claims were based on fairly standard conduct. So the employee coming into work after hours, taking material home to do work. There was a couple of little minor breaches, but nothing major by that employee and nothing that gave rise to cause. Now, the most notable part about this decision is really the employee's claim for wrongful termination. And the court upheld that claim, awarded the balance of the articling period, so the remainder of the 12 months of articling, and also awarded $50,000 for aggravated damages. And that is quite a sizable award in BC. And that's kind of worth kind of explaining a little bit. So the reason for that was a few factors, one of which was the lack of investigation. So there was no investigation, no chance for the employee to explain this blog. Also, the law firm served the student in front of her classmates while at PLTC. And the firm tried to explain that, saying it was necessary, but the court found that wasn't the case, that it was intended to embarrass her. There were also accusations of deceit and dishonesty, which were maintained by the firm throughout the trial. And the court also noted the fact that this lawsuit and complaint would render this student unemployable until the matter was resolved. So this is a cautionary tale, and just these facts are quite extreme, but kind of the takeaway here I would mention is just that the manner of dismissal and also allegations can have serious monetary consequences. So it is important to just give some thought and reflection prior to taking those kind of steps or maintaining those kind of allegations. And again, this is kind of what I mentioned before, but just the importance of carrying out a thorough investigation, and in particular, giving the employee a chance to respond to any allegations. A failure to do that will not turn out well in court. So now turning to the next decision, and this is Rice versus Shell Global Solutions. And this was a decision of the Alberta Queen's Bench. And this goes to kind of the issue of fixed term contracts, which has received a fair bit of attention from the courts in the last couple of years with some notable decisions. So in this situation, it is a little unique in terms of these fixed term contracts. And the reason is that this employee commenced employment with Shell in 2008, or commenced work, I should say, with Shell in 2008, and was initially on a number of contract positions and then eventually secured employment. And then in 2016, she applied for and was awarded a new position and received a hiring letter. And that hiring letter, among other things, mentioned an assignment length of 4 years. The letter also said that the full terms and conditions of employment were not set out in that letter and would be provided by the manager. Now, the employee inquired with the manager about any other terms. She did so the day after she received that hiring letter and never received a response. So her evidence was that she assumed that that letter did in fact contain all the terms of employment. Approximately a year after she was hired into that new position, her employment was terminated upon 3 months' notice. The employee sued, claiming an entitlement to 34.5 months damages, which was the balance of that 4-year fixed term contract. Now, this whole case really centered around the meaning of the language assignment length. You'll recall the hiring letter mentioned an assignment length of 4 years. Now, the plaintiff's evidence at the trial was that she understood that assignment length to refer to the time in her position and that she was provided a 4-year employment term in that position. Now, Shell referred to evidence that the assignment length referred to something else. It referred to the expected time in a position before an employee can apply to another position, but that it wasn't a guaranteed term of employment. And they mentioned that this was published in a document that was part of an internal glossary of terms and was contained in the employer's internal network of documents. The plaintiff's evidence was that she was unaware of the special meaning and that it was not incorporated into the contract. Now, the court found in favor of the employee. They found that the assignment was not guaranteed employment for 4 years, but rather, a guaranteed employment for 4 years, but would not automatically end at the end of that term. So it was guaranteed 4 years, and then after that, there would possibly be more employment, but it wasn't just an assignment. And the evidence here, and this is quite a helpful decision, just in kind of setting out some of these basic principles around contract formation. So one of the issues here was that that glossary of terms or any kind of internal policy document was not incorporated into that employment agreement. There was nothing referring to it in the hiring letter, and it was not provided to the employee. This is also a good reminder of the danger of fixed term contracts and just the potential that they do end up leading to a guarantee of employment for that period of time. There was some good news here, though, and that's that this decision was distinguished from an Ontario Court of Appeal decision from a couple years ago, which was Howard versus Benson. Some of you might have heard about that. There were a lot of articles published about it, including from Fasken. And there, the court found that an employee's mitigation, so any employment they earned during that time period after they were terminated during the fixed term, would not be discounted from the damages they were owed. That was not the case here. So the court distinguished that, which is interesting, and it'll be interesting to see if other courts follow that. So it's not all bad news, but just a good cautionary tale about fixed term contracts. And with that, I'll turn it over to Bonny Mack, who's going to discuss Matthews versus Ocean Nutrition.
So another thing that can cause as much trouble at the time of termination of employment as a fixed term contract are long-term incentive plans. So there is a case, a decision from the Supreme Court of Canada that came out this year, Matthews and Ocean Nutrition Canada Limited. What was at stake in this case was a payout of over $1 million under the long-term incentive plan. So Mr. Matthews was employed as a senior executive at the company, and he, as a part of his compensation package, he was entitled to a long-term incentive plan. And it is one of the terms of the plan that upon the sale of the business, participants in the plan would be entitled to the payment of a specified share of the sales proceeds. The plan also specified that if an employee was not actively employed at the time of the sale, then the employee would not receive a share of the sale proceeds. So what happened in this case was that the employee, Mr. Matthews, was constructively dismissed. And he took the position that he had been constructively dismissed, and he left the company's employ. About a year after that, he left the company was sold, therefore triggering that payment that was payable upon the sale of the business. But by that time, Mr. Matthews was long gone from the company, and the company took the position that Mr. Matthews was not entitled to that $1 million payment under the LTI plan. So that was the issue, the main issue that was dealt with by the Supreme Court of Canada. Was there an entitlement to that $1 million payout under the LTI plan? So when the court when a court looks at this type of issue, it asks two questions. The first question is, would this employee have been entitled to that payment had he remained employed during the common law notice period? In this case, the common law notice period was determined to be 15 months, and the sale of the business occurred 12 months into 12 months following Mr. Matthews' departure from the company. So the triggering event was within the common law notice period. So the first question was yes, if Mr. Matthews had been actively employed, he would have been entitled to that $1 million payout. The second question is, does the language in the LTI plan clearly disentitles the employee from that payment after the employee is no longer working with the company? In this case, the court looked at the contract language, looked at the language under the LTI plan, and determined that the contract language was not clear enough to displace the common law presumption that Mr. Matthews was entitled to this payout. So some of my clients ask me, well, how is this new? We've been hearing about this. There have been other cases. So why is this now a big deal? Well, first of all, it's a Supreme Court of Canada decision. So of course it is a big deal. And the second thing is, I have a lot of clients who say, well, that doesn't apply to me because our plan clearly states that employees who have left the company, who are no longer actively working, they're not entitled to things like bonuses and LTI plans. So I'm not concerned at all. But let's take a look at the specific language in this LTI plan, which is on the next slide. It's a little bit small, and during COVID, I've developed really bad eyes. So bear with me for 1 second. So this is the actual language which I cut and pasted from the judgment. This is the language that was actually in the LTI plan. So it says, the company shall have no obligation under this agreement to the employee unless on the date of a realization event being something like the sale of the business, the employee is a full-time employee of the company. For greater certainty, this agreement shall be of no force and effect if the employee ceases to be an employee of the company, regardless of whether the employee resigns or is terminated with or without cause. So those are a lot of words, and a lot of us who are not lawyers would probably think that that seems pretty clear, that all those words, that paragraph means that if an employee no longer works for the company, it doesn't matter whether the employee resigns or was terminated with cause or without cause, there is no entitlement, no force and effect if the employee ceases to be an employee of the company. That is the language that the Supreme Court says is not clear enough. So same thing with the second paragraph there, where it says the long-term value creation bonus plan does not have any current or future value other than on the date of a realization event and shall not be calculated as a part of the employee's compensation for any purpose, including in connection with the employee's resignation or in any severance calculation. So this second provision there expressly states that payments under the LTI plan is not to be included in any severance calculation. That language is also held to be unclear and, well, not clear enough to displace the employee's entitlement to payments under the LTI plan during a common law notice period. For those of us who think that our own plans have language that are clear enough, perhaps it would be a good idea to take another look. I understand that Magali has some comments to make about this case from a Quebec perspective as well.
Yes, I do. So thank you, Bonny, for your comments. And I have to say that when looking at the terms of the contract, it's the result and the decision is very surprising because it does look at first glance like the terms are very unambiguous and clear. And unfortunately, the Supreme Court was not very generous in their reasons in explaining how the clause or the provision should have been drafted. So there's a lot of question mark for employers, but also for us attorneys to know how a clause would be considered to be well drafted under law. But just to let you know, in Quebec, I think we have good arguments to claim that this Supreme Court decision, because it arises from a common law province, would not have the same application in Quebec. So in Quebec, the particularity is we have section 2091 of our civil code, which provides that both parties may terminate the employment agreement by giving notice of termination. And up until now, the case law in Quebec has given an interpretation to this section by saying that employers may opt between either giving a reasonable notice, so working notice, or an indemnity in lieu of. And the courts have confirmed that opting for a payment in lieu of notice does not constitute a breach or a fault. And so the case law has developed a principle under which when opting to pay an indemnity in lieu of notice, the employers will have to pay the benefits that the employee would have received and the short-term incentive payments that they would have been entitled to during the notice period. But the majority of the Quebec case law, including the Quebec Court of Appeal, has considered that a long-term incentive plan, such as this type of plan or a stock option plan can be distinguished from short-term incentive plans. And so it is generally recognized that long-term incentive plans are different because they are viewed to be enforced in order to encourage an employee to remain employed by the employer on a prospective basis, rather than to compensate the employee for the work performed. And therefore, it would be too generous or abusive to expect to be remunerated for a compensation that relates to the fact that you should be maintained in your employment rather than a form of compensation to compensate you for your performance. So that distinction has been generally recognized. Of course, it is important to have clear terms in a contract or in such a plan. And it'll be interesting to see if that case law is maintained despite the language of the Supreme Court. I think that what we've always been able to look at is the fact that 2091 of the Civil Code specifically permits both parties to terminate an employment agreement, should permit also an employer to contractually stipulate that some of these long-term benefits should also cease upon termination of employment. So case law to follow depending on the impact of the Supreme Court decision. And now we will turn to the ugly, Karen, not that you have the tough job to start with the Waxdale decision, and to thank you.
Thanks, Magali. Never great to be introduced as the ugly, but I guess I'll take it today. So the first case that I wanted to talk about, or we wanted to talk about in the ugly, is one of the biggest cases of the year. And this is the Waxdale decision. And it concerns the enforceability of termination provisions. So I think for years, the last decade or so, we have really watched the courts whittle away at termination without cause provisions. So first, we know that they weren't enforceable if they didn't meet the employment standards minimums. And then they weren't enforceable if they didn't refer to benefits continuation during the statutory notice period. And then they weren't enforceable if they did not meet the employment standards minimums at all times. So, even if the person was a 2-year employee, it didn't meet the minimums as if they had been a 10-year employee. Then we had it wasn't enforceable if they don't say anything about it being the entire agreement or entire entitlement, and so on. So this is one more in the series of the courts whittling away termination provisions, which is why it's under the ugly category. And what's new in this case is the court looked at the enforceability of the termination for cause clause to determine whether that invalidated the termination without cause clause. And here it said because the for cause clause was not enforceable, it invalidated the entire termination clause. So something really new, really shocking from the Ontario Court of Appeal. So let's look at it a little more closely. So in this decision, Waxdale had less than 1 year of employment. He had a termination provision in his employment agreement that would provide him with 2 weeks pay in lieu of notice. That termination without cause provision is on the screen now. Turning to the next page, there was also a termination for cause provision. And this was a lengthy provision, and interestingly enough, it's not even found in the decision, but we have seen copies of it. It was a very lengthy provision that set out 9 different grounds that constituted termination for cause. And the 9th ground was, and any other matter recognized by the courts to be cause. And the provision provided that in any of those cases, any of those 9 grounds, employment could be terminated with no notice or no pay in lieu of notice. What the termination for cause clause didn't do is it didn't recognize that not all of the 9 grounds involved willful misconduct, willful disobedience, and willful neglect of duty. And the reason why those concepts are important is in the Ontario Employment Standards Act, an employee is only disentitled to notice, pay in lieu of notice, or severance pay if the conduct meets one of these three thresholds. So willful misconduct, willful disobedience, and willful neglect of duty. If they engage in behavior that is otherwise cause, and so they don't get common law amounts, but it doesn't rise to the willful standard, they would still be entitled to their employment standards minimums. So if they don't meet those standards, it wouldn't be cause pursuant to the Employment Standards Act, and so therefore they would get those entitlements. In this agreement, so just to back up, in the termination for cause clause in this employment agreement, it was suggesting that you would get nothing. But if in fact the behavior didn't rise to the willful threshold, the employee would get the Employment Standards Act minimums. And that's where the court said that the termination for cause clause was not enforceable. Also importantly, the employment agreement had a severability clause, which is on the bottom of the screen. And it essentially said if one clause is unenforceable, then the other clauses in the termination or in the employment agreement remain valid. So turning to the next slide, the parties in this case agreed that the termination for cause clause was invalid for the reasons I suggested, in that it didn't contemplate that your employee would still get the employment standards minimums if the cause did not meet the willful threshold. The plaintiff argued, the individual argued, that the termination for cause clause being invalid invalidated the entire termination provision. And the company said, doesn't matter, irrelevant, because those clauses, the termination for cause clause and the termination without cause clause, are two separate provisions. One being invalid does not invalidate the other. Turning to the next slide, the initial judge on the summary judgment motion agreed with the company and said the termination clauses were separate and apart. So just because the termination for cause clause was invalid didn't invalidate the termination without cause clause. Unfortunately, as the next slide suggests, the Ontario Court of Appeal did not agree. And this is what really shocked employers and employers' counsel throughout the province. The Ontario Court of Appeal said the entire termination provision was unenforceable and the severability clause didn't apply. And what was really shocking is until recently, most termination provisions, termination for cause provisions, said something like, if you, in the event your employment is terminated for cause, you will receive no notice, no pay in lieu of notice, no severance pay. And they didn't carve out unless the Employment Standards Act requires otherwise. And so the result of this is that probably in about 99% or 95% of termination, in 95% of cases, that would mean the termination provisions are unenforceable. And this is just a shocking result. So then that leads us to the next slide, which is what have other courts been doing? Are courts going to follow this? Well, we have seen one court in Ontario in this decision, Sewell, applied the Waxdale decision and said that the unenforceable termination provision that you see on the slide here invalidated the entire termination provision. One of the questions that was submitted before we started the webinar was what other provinces are going to do. We haven't yet seen decisions from other provinces, but I would not be shocked whatsoever if other common law provinces, so other provinces but for Quebec, started to follow the Ontario Court of Appeal's decision. Now, there is some good news, tiny bit. The case is being appealed to the Supreme Court of Canada, and we're hopeful that the decision of the Ontario Court of Appeal will be overturned. But in the meantime, we live with the decision. So what can you do? If you haven't already, you should review your current employment agreements and assess whether, you should always be looking at your termination without cause clause, but we should take a fresh look at your termination for cause clause and assess whether that in and of itself is valid. If it is not valid, then you've got a decision to make. One decision is to live with the risk. Another decision or another choice is to revise the termination for cause provision. Of course, if you are going to revise that provision and have individuals enter into new employment contracts, you do need fresh consideration. And so sometimes that in and of itself creates more fuss. And so many employers decide to live with the risk and fix the issue going forward. All of which is to say, I think this is just another sign that the courts really don't want to remove an employee's right to common law notice. They really don't want to enforce termination provisions that drastically reduce that severance period. And so another question in the questions was, is it ever going to be possible to draft an ironclad termination provision? And I think the answer is, I don't know, because every time we get one of these decisions, we change the termination provisions and we think it's rock solid. And then we see another court whittle away at it. So I suspect we all know the answer, but hopefully the Supreme Court of Canada will change its mind or change our minds on this one. So another ugly case involves certification of employment class actions, and I'm going to turn it over to Magali to tell you about that.
Yeah, so thank you, Karen. So as part of the ugly, I'm also presenting you this decision. There's only very, very few cases that have dealt with class actions in the employment sector. There's been a few cases in the federal sector, but in Quebec, it's very rare and unusual. So this decision was rendered by the Court of Appeal, and it actually reversed a decision of the Quebec Superior Court, which had been favorable to the employer because it had refused to authorize a class action against two employers' arenas in this matter. Just briefly, the class action was undertaken by two salaried employees on behalf of all other employees of those employers that had been remunerated on an annual salary. Of course, it was with the exception of managers, because managers are excluded from overtime provisions in Quebec. So any employees remunerated on an annual salary who had worked more than 40 hours in any given week in the past year were covered by this class action. And so it was a very, very detailed decision rendered by the Superior Court, very convincing, a lot of reference to case law and also to the facts of this case. And the main argument of the judge that heard this recourse in 2019 was based on Section 55 of the Act, the Quebec Act Respecting Labor Standards, which states that any work performed in addition to the regular work week entails a premium of 50% of the prevailing hourly wage paid to the employee. So the Superior Court held that the language found in that article, it has been unanimously decided by the courts that overtime provisions would not apply to employees remunerated on an annual salary because Section 55 only allows overtime pay to employees that are paid on an hourly wage. So the judge made a very detailed analysis of that case law and was very convincing in reaching that conclusion. But then she went to discuss a second alternative argument of the plaintiffs, which was that when hours of work are controlled by the employer, it is sometimes possible to conclude that there is an hourly rate that exists, and as such, the overtime pay could be calculated because we are able to come up with an hourly rate and therefore make a calculation for overtime. So this is where the judge also made a very thorough analysis of the facts alleged by the plaintiffs in their class action. And while she recognized that the argument of the plaintiffs could theoretically appear to justify the conclusion sought, she reviewed those facts and determined that even if the plaintiffs' allegations were held to be true, the documents that had been provided by the plaintiffs were not sufficient and did not demonstrate that the employers exercised sufficient control over their working hours in a way that it would become possible to calculate a usual hourly rate. So there were other arguments that she had raised, but basically in her mind, the plaintiffs had no defensible personal case against the defendants. And she decided that the mere fact that the employer recorded the hours worked was not sufficient to open the door to overtime pay in this file. And so what the Court of Appeal did, and that's really in the, it's an approach that is very consistent with the recent Supreme Court judgments on Quebec class actions, which have confirmed a very low threshold for class action authorization. The Court of Appeal said that the trial judge made an error and went too far when she evaluated the facts. She should strictly have decided whether the facts alleged appear to justify the conclusion sought. And so unfortunately, this means that the class action for overtime is now allowed and is following its course. It will be very interesting for employers to see if the new decision confirms that first decision and the principle that under Section 55, of the Labor Standards Act, when you have an employee who is paid on an annual basis, an annual salary, that employee is excluded from overtime provision. It's been a way for employers for many, many, many years to be able to get around and have some kind of certainty regarding overtime pay, but this is being challenged in this decision. So it will be a very important case to follow in the next few years. Thanks. And now I will pass it to, is it Bonny, who will discuss whistleblower protections.
Thanks, Magali. Before we go on to the last topic of the day, which is whistleblower protections, I wanted also to mention, following what Magali's remarks about class actions. Of course, employment class actions are alive and well in the rest of the country as well. Recently, we've had the decision that came out in the spring where CIBC was found liable for requiring or permitting uncompensated overtime to be worked and for failing to accurately record all hours worked by frontline bank employees. So just a brief note to say that unfortunately that is now a feature of Canadian employment law. So last but not least, in the ugly section, is a case that is not really your typical employment law case, but it is in the context of a settlement of prosecutions by the Ontario Securities Commission against a market participant who was the prosecution against a market participant as a market participant, but also as an employer. So as some of you may know, those of you who work in the financial services industry, the Securities Act prohibits reprisal action against employees who are whistleblowers. In other words, if an employee raises a concern about non-compliance with securities law and subsequently suffers adverse employment consequences, that is a violation of the Securities Act. So what happened in this case? So in this case, the company was, they operate a crypto asset trading platform. So this is a relatively new thing. And in fact, it is the first ever OSC prosecution against a crypto asset trading platform. So what this trading platform does is that it facilitates the buying and selling of crypto assets. And then what happens, what this company did was, as it is running this platform, they decided to put through a series of fake trades, buys and sells trades that are processed simultaneously to make it look like there are a lot of trades going on. In fact, at one point, these fake trades consist of about 90% of the trades that were showing on this platform. So they had an employee who was hired to who was hired to run these algorithms, and during the course of his work, this employee became aware of these fake trades and reported his concerns about the practice to senior management. He reported it to the president of the company. The practice of fake trades briefly stopped, but then resumed. This employee then continued to report the practice, expressing his concerns to management. Management did not heed his warnings, and they kept on with the practice. And they told the employee that if he continued to raise concerns about these fake trades, it would impact his employment. So then the employee subsequently took a stress leave as a result of the stress he experienced from having discovered these fake trades, having reported them, and having his employment threatened. He went on stress leave, and while on leave, the company terminated his employment. So the Ontario Securities Commission commenced an investigation into these circumstances, and eventually a prosecution was initiated, and it resulted in a settlement agreement. Now, I should say that this settlement agreement is a global settlement agreement about the entire story we just heard here, not just about the reprisal action that the company took against the employee. So I should back up and say, you know, there was an investigation, there was a prosecution, and the company admitted that it had engaged in these fake trades in an effort to manipulate the market, and it also admitted that it had taken reprisal actions against the company, against the employee who was the whistleblower. So what makes the story kind of an ugly one is what the terms of the settlement was. So 4 parties were charged: the company, the president and founder of the company, the CEO, and the chief compliance officers. And all of these parties paid a fairly heavy price. So the company had to pay $200,000 towards the Ontario Security Commission's costs of conducting the investigation. The company's former CEO, he agreed to pay $1 million in administrative penalty and $50,000 in costs to the Ontario Securities Commission towards the investigation costs. He also was banned from being a director and officer of a market registrant within the meaning of the Securities Act for a period of 3 years. The president and founder of the company paid an administrative penalty in the amount of $900,000 and $50,000 in costs to the OSC. He also agreed to a director and officer ban of 2 years. The chief compliance officer agreed to make a voluntary payment in the amount of $50,000 to the Ontario Securities Commission. And he also agreed that he would be prohibited from becoming or acting as a director or officer for a registrant for a period of 1 year, commencing on the date of the order. So the last point I wanted to make about this case is that it is, as I mentioned, the very first time that the Ontario Securities Commission has gone after crypto asset platform. It is the first time the Ontario Securities Commission has dealt with allegations regarding market manipulation involving crypto assets, and it is the first time it dealt with an issue of reprisal against a whistleblower. And in the oral reasons for the approval of the settlement, it was commented that it is not unusual in settlements at the first of their kind that sanctions may be less severe than they might otherwise be in less novel circumstances. What that means is, be warned, subsequent parties who may run afoul of these provisions of the Security Acts will likely be subject to higher penalties than what we see in this case. So that wraps up our presentation. I believe that we have some time for questions and answers.
Great, thanks, Bonnie. So a couple of questions have come in. I'm going to give the first one to Matt Larsen. Matt, if you include a clause in a fixed term agreement stating that either party can end the agreement with 30 days notice, does that provide some protection?
Thanks, Karen, and thanks for that question. So certainly you can include a termination clause in a fixed term contract, and we would recommend doing so. The important thing to note is that in order for that to provide protection against the kind of damages I mentioned, which would be having to pay out the employee for the remainder of the fixed term, the termination clause is going to need to be compliant and enforceable. And what that means is that the termination clause, just like in any employment contract, needs to comply with the employment standards minimum. So it needs to at least meet that. Otherwise, what will happen is that it will be struck from the contract and not enforceable. And we've seen that happen in some of those cases I referred to over the last couple years. Termination clauses have been deemed to be unenforceable and therefore struck. And, Karen talked in her, when she was talking about the recent Waxdale case, how strict the courts are becoming around the enforceability of termination clauses. So that clause is going to need to be drafted very carefully. Otherwise, a fixed term contract does run that risk. But certainly a well-drafted termination clause can provide that protection. It just needs to be carefully drafted. And the one thing I would note here with the Shell case in particular, there where you've got this employee who was an employee and a contractor for a number of years prior to this most recent agreement, that fixed term agreement, in that kind of situation, that further complicates matters because there's the issue of this past service and how that would be calculated for purposes of a termination clause. So that's certainly an area where, we would strongly recommend, seeking legal advice to consider how to create an enforceable termination clause.
Yeah, that's right. And I can't stress that enough, what Matt said. So often when we see a termination situation involving a fixed term agreement, it's not the first fixed term contract. It is one in a long series of fixed term contracts. And so we know that the courts will at some point basically treat the employee as having been an indefinite employee. So in terms of fixed term contracts, if I'm involved drafting one with a client, I always ask the question, why do you want this to be a fixed term? Why can't this be indefinite term and we just terminate when we no longer want the employee? Now, obviously in jurisdictions like federal jurisdiction and Quebec jurisdiction, where you've got unjust dismissal protection, that's a different story. But in most of the jurisdictions, I just have so often seen either an employee has employees employed on this series of fixed terms, or they allow the employee to stay 1 day beyond the end of the fixed term, in which case you're into a whole other ball of wax. So really do look at those cases or look at those contracts and see if you need it to be on a fixed term. Another question, Bonnie, I'm going to give this one to you. It's a question about bonus plans. And the question is, what do you recommend employers do to protect the payout of a short-term bonus for someone who leaves during the bonus plan, fiscal year, or term before payout?
Well, there are a couple of things that I would suggest that employers do. The first is to actually look at your employment agreement and look at that termination provision. Recall that these bonus and LTI plan payments would be payable during the notice period only if they if the scheduled payout date fall within the notice period itself. So by tightening your termination provision, you reduce the uncertainty of what that notice period would be in the event of termination of employment. Of course, if you don't have any termination provision at all, then the common law applies. Then that's when you have a lot of uncertainty about the length of the notice period and whether a bonus payment or long-term incentive plan payments would fall within the notice period. So that's the first thing, is to take a look at your employment agreement, make sure that we tighten up that termination provision. Secondly, is to take a look at your bonus plan. A lot of employers don't really have an extensive bonus plan. They may have a document that sets out how bonuses are calculated, when it's going to be paid out, all the good information that employees are interested in because they want to know how big their bonus is going to be. But lots of times there aren't actually a lot of language around what happens to a bonus payment if an employee leaves partway through a fiscal year or partway through the bonus cycle. So the best thing an employer can do is to have a properly drafted provision which makes it clear to the employee what happens to the bonus payment if one is to leave partway through a bonus period. Of course, if you have been listening to this presentation, you will know that both termination provisions and provisions limiting employees' entitlement to a bonus or to long-term incentive payments during a notice of termination period is constantly under attack by employees, and judges seem very eager to find new ways of invalidating those clauses. So what that means is we need to look at these, we need to look at language like that, ideally on an annual basis. There are new cases coming out all the time, and new ways that Employees Ad Council and judges are coming up with to whittle away the termination provision and provisions in the bonus and long-term incentive plans all the time. So we really recommend having an annual review in place to make sure that you've got best-in-class language in both those documents. That to me, it's the best way, albeit perhaps not the perfect or ironclad way of protecting ourselves in those circumstances.
Thanks, Bonnie. Another question, and maybe I'll answer this one since I was responsible for putting it in the ugly section. A question has come in, is why was that last case about the whistleblower protection in the ugly section, since it sounded like quite a gross violation of the officers of the company. And the reason why we had it in the ugly section is this is really the first case of this kind. Whistleblower protection in a Canadian jurisdiction is very new. Ontario is the first jurisdiction to have it. We are seeing it crop up in other jurisdictions as well. And it's just one more way that employers can be hammered by a regulator or a court or whatnot. And so that's why we put it in the ugly jurisdiction, or the ugly section. I think you're quite right, the person who's asked the question, that this was very bad behavior. And so we probably won't see this protection invoked very often, but it is something that's new. One of the questions we had by one of our callers or one of our viewers before we started the presentation is, what is something we should be made aware of that seems to be emerging in 2021? And I thought maybe we would just go through all the panelists and get a sense of where we see things heading for employment litigation in 2021. And Magali, maybe we can start with you and Quebec.
Sure. Obviously, it's hard not to talk about COVID, the situation, and I think that the way that some of the employers have applied either the labor standards provision regarding collective layoffs or even the termination provisions of the Civil Code, and using the exception of force majeure. I'm not aware of a litigation pursuant to the application of the force majeure exception, but I do have clients that have applied it, and I'm curious to see if there will be some case law. It's probably going to be not on the short term. It will probably take a few years before we finally hear about it. But certainly it's something to watch closely.
Thanks, and I suspect for each of us in our jurisdictions, that's where we see things heading as well. But Matt, maybe I can get from you, aside from COVID or aside from what Magali mentioned, where do you see things heading in 2021?
Yeah, certainly. So, aside from COVID, I think I've spoken with plaintiff counsel in BC here, and I think one of the things we're going to see is how the Waxdale decision is going to apply in BC. I know plaintiff counsel were very happy to hear about that decision and are looking forward to seeing, how that might be applied by the courts here. That will be interesting because our legislation in BC has a different language. So it doesn't have that kind of specific language about what will constitute just cause under the Employment Standards Act. So I think there will be some interesting arguments around that and whether that applies here or not. BC courts have tended to be a little less aggressive in kind of chipping away at termination provisions out here. But it's certainly a trend. Like, it's not that much different, but I do think that's one of the things. And then, another couple interesting kind of pieces that I'll just mention, because I think these are covered in some of our other seminars, but with the Human Rights Commission coming out here, I think that will be interesting to see kind of the impact that plays in BC, and then the new federal privacy legislation, which was recently introduced. So mention those kind of as side notes. You might want to tune into some of those other seminars we've done. So
great, thanks, Matt. And Bonnie, where do you see things going in 2021?
I last year at around the same time, I did a presentation on year in review as well. And at the time, I expressed a lot of concerns about the delays in the human rights system in Ontario. I think at the time I gave some examples of cases that took over a year to resolve, and how cases that had been assigned to a vice chair had a summary hearing occurred and then had to be rerun. The hearing had to be rerun because the vice chair did not render a decision before her term of appointment concluded. So I told all those stories last year and was hoping that things would become better in 2020. And then of course COVID hit, and everything other than some mediations appears to have ground to a halt. We've had a lot of hearings canceled during COVID. The tribunal in Ontario doesn't appear to have great capacities to conduct online hearings. So hearings that were scheduled for May or June of 2020 were canceled, and we have yet to receive notices from the tribunal about when they're going to be rescheduled. So it's definitely a concern on the part of both complainants and also employers and companies who are defending these human rights complaints, because as the delays mount, potential liability may also keeps accruing. So that's something that we'll continue to keep a close eye on in 2021. And then of course in Ontario, there is finally going to be private sector privacy legislation. So that's definitely a major development that we would be monitoring and updating our clients on. Karen?
Great, thanks, Bonnie. And just from my perspective, I see things similar to Magali with more COVID. In particular, in addition to the group notice and extended layoffs, termination entitlements. Are we going to see employees being given larger common law packages because it is more difficult to find employment? Certainly in every single demand letter we've received involving a termination since March, we have seen a claim for that. This person, might have been entitled to 6 months notice, but they should get 8 or 9 because it's going to take them longer. So I think we're going to continue to struggle with that. Another question, Magali, maybe I'll throw this one at you. And this might be a joke, but it might not, I'm not sure. An individual says, I noticed this summer many employees working from home at a golf course I regularly play at. Any thoughts on this? The golfing part might be a joke, I'm not sure, but I think we've all had experience with folks that are supposed to be working from home, but not necessarily working or at home. So thoughts on that?
Yeah, it is something that we unfortunately have to deal with, and all the working from home and the surveillance that an employer can actually bring is important. But I guess it's all a question of flexibility, and of course, a lot of employers have requested some flexibility from their employees and are in certain circumstances being much more tolerant for their employees who may have had some difficult circumstances. So before seeing any of the sanctions taken against some of these employees, I think employers will need to make sure that they have policies for teleworking and making sure that the lines are very clear in terms of what's expected or not, especially for employees who have a lot of discretion in terms of their hours of work. And a lot of them could always say that they've been working at different time, but have been responsive and basically have been meeting expectations, although they have been on the golf course. So I think that if we want to make sure that these situations don't amount to litigation, employers will need to be very clear in their communications with their employees, either in policies or expectations.
Great, thanks. And I think the other overlay we have on all of these working from home cases is whether family status is at play. Are people not able to work because of childcare responsibilities and whatnot? So that's something else you want to be thinking about. Another question, and I'll open this up to any of the panelists, is whether there have been any court decisions involving marijuana since marijuana has been legalized. Does anybody want to take that? Well, maybe I'll jump in. From my perspective, we're not seeing any significant court decisions dealing with whether drug use in the workplace is treated differently since it's been legalized. The same principles apply with respect to drug use in the workplace and alcohol use in the workplace, since marijuana has been legalized as it applied before. So we're not, unless one of my panelists corrects me, which I welcome them to do, we're not seeing any significant decisions dealing with marijuana in the workplace since it's been legalized. That pretty much sums up all of the questions that we had. There were a lot of questions before the presentation about COVID-19 and layoffs and different types of leaves and all sorts of things related to COVID-19. We have addressed COVID-19 a little bit here, but we wanted to make this presentation about what else has been going on in the world. And that does not to say that that COVID-19 hasn't been significant. We know it's been extremely significant this year. We continue to work through COVID-19 situations with our clients and have been doing so since day one back in March. We have put out a lot of materials on COVID-19. So if you do go to our website, we've probably got about a half a dozen or so presentations on COVID-19 at various stages of time. We've got many materials on COVID-19 specific matters. So I do urge you, if you do have specific questions, to go back and look at those various pieces that are on the website. We are putting out another publication today or tomorrow that will deal with the update in Ontario and deal with the status of where things are at with other provinces. So I do urge you to check our website if you have questions related to COVID-19, or reach out to us individually. So if nobody else has any questions and the panelists don't have anything else to say, we will say goodbye now. Thanks very much for joining us.